before. Is that right?
Yes, Michael Latour, Land County Probation.
Okay. Ms. Dianuntis, is the state deferring?
Yes, Your Honor.
Okay, I'll hear Mr. Latour. Go ahead.
Okay, Your Honor, in front of you is Sarah Smith. The VOP was originally heard on October 4th, 2019. At that time, it was postponed to 2/14/2020, where Mrs. Smith failed to appear. A bench warrant was issued, and the warrant was executed on March 8th, 2020. And then she ended up in a Land County jail. Well, Judge, within that time frame of the postponement, Ms. Smith was charged with a new charge. She was charged with hindering, give false information, and she was also charged with identity crime impersonating value under 500. However, Judge, it should be noted that that charge was transferred to the prosecutor's office on 3/9 and assigned a file number, but it was administratively dismissed on 3/12/20. But just to let you know, she did pick up a charge during the time of postponement. During the time of postponement also, Ms. Smith failed to report as directed on February 12th, 2020. Judge, substance of the postponement was for her to engage in treatment. During that postponement time on 2/3/20, Ms. Smith was unsuccessfully discharged from John Brooks Recovery Center due to what they say was continued drug use. She was referred to detox and was to transition into long-term inpatient treatment at that time. As of the writing of this addendum, she has not done so.
All right, probation's recommendation is drug court. Is that right?
Oh, yeah, Judge, if you want to cut through, because there's many charges against her, but if we go right to the recommendation, Judge, our recommendation would be for the client to apply for drug court. If she's not eligible or not interested in drug court, then probation would recommend that if the client is found guilty of the violation, she'd be sentenced to a term of incarceration in Your Honor's discretion. And at the end of that term, that probation be terminated without improvement.
Okay, and she's on probation for a third-degree offense. Is that right?
Judge, I have limited paperwork on me. I just have the addendum document. Let me check on.
Let's assume that that's accurate, and that you can check while you talk to me. But assuming it's a third degree, and assuming I find her guilty of having violated her probation, and if she doesn't want drug court, then I have up to 5 years New Jersey State Prison on the table for Ms. Smith. Is that right?
Oh, that is correct. That would be the high presumptive on third degree.
Okay. Well, let me hear Mr. Aguilar. Mr. Aguilar, I don't mean to cut you short, but the question I have is she interested in drug court?
She's interested in treatment, Your Honor. My understanding is that she has already engaged herself in medically assisted treatment at the county jail, and that upon her release, she is scheduled to continue that treatment.
Well, that didn't work out before for Ms. Smith. So I guess at this particular point, you know, her choices are drug court, or her choice is drug court, or we can talk about a state prison sentence. I know that you're at a disadvantage because you can't talk to her, but I'm not inclined to release her to the street so that she can follow her own course of treatment, because that didn't work before. And so, does she want to fill out a drug court application?
Well, Judge, she may very well, but I brought a motion to have her released on bail, Your Honor. I wasn't quite prepared to address the VOP on the merits. quite frankly, one of the reasons that I brought this application because her violation of probation was not scheduled until the end of the month. And
I'm not going to give her an ROR on a VOP where she can't remain law-abiding and appears to be continuing to use drugs. If I let her hit the street, she's going to continue her criminal activity and she's going to continue to use. She needs drug court. Her own treatment plan isn't working. She's got a VOP scheduled for the 20th.
Yeah, I believe that that's the case, Your Honor. If I could just suggest to the court that perhaps the court could release her, allow her to do what she says that she wants to do, and then have her come back on the scheduled date.
Okay, well, go ahead.
The situation is this, Your Honor. She is on probation for a possession of CDS charge, a third-degree offense.
Right.
That's her only indictable conviction. The charges that were incurred by defendant that the probation has mentioned, as the probation mentioned, those have been apparently dismissed. So there are no pending charges against her, Your Honor. And I think under those circumstances, it would be appropriate to release her to continue treatment on her own, Your Honor, because of the, I would suggest to the court.
Do you hear, Mr. Latour? Evidently, she was discharged from treatment because she couldn't stay off of drugs.
Yeah, that was within the discharge. And just to correct the record, Your Honor, she does have a pending charge. Omar, the counselor, the charge that I mentioned dismissed, I didn't get to the whole laundry list of charges. There is still an active charge that's pending. It was a possession case and a possession of a hypodermic syringe and hindering, giving false information. Like many of those cases now, they did get remanded, but that does have an active court date. So she does have an active ACS matter, an active criminal matter. And also, Judge, just for the record, as you may have the document, there's just a cavalcade of self-reported relapses that have indicated ongoing drug use. And I'm kind of in agreement that to release her on her own recognizance and for her to follow her own plan would be folly at this time.
Okay, all right. I reviewed the record and the application.
May, Your Honor.
For an Mr. Aguilar, I've considered your argument and I'm not letting her out.
But I'm not.
For an ROR is denied. If you want to get to the jail and get her a drug court application, she'll be tasked and she'll be given a level of treatment. But I'm not
Your
letting.
Honor, with all due respect, Your Honor, I don't think that the court allowed me to continue the argument, Judge. The reason that I brought this motion is because of the public health crisis.
Okay, I've considered that, counselor, and I know that you want to talk more, but I'm not going to let you. The application's denied. We're off the record. Thank you.
Thank you, Your Honor.
Thank you.
Ensure the safety of the community. And because of that, we asked that the defendant remain detained. Judge Cunningham did consider everything and found that he should be detained for the safety of the community.
Well, Ms. Linehan says that he's PTI eligible. I mean, were there discussions about PTI?
Yeah, Your Honor, I'm sorry.
That's okay. Let me hear from Ms. Dianuntis, and I'll go back to you, Ms. Linehan.
Thank you.
Yes, Your Honor. He would be PTI eligible with compelling circumstances. He would have to submit, and he does have a second-degree charge, which was possession of a weapon in conjunction with a drug offense.
But I think Ms. Linehan told me that you guys were in the process of working this out.
I did prepare an accusation for the other case, Your Honor. However, he would still have to apply to PTI and would have to be accepted, which is not something that I'm in control of.
All right. I mean, let's assume for the moment that we were in regular court under regular circumstances, and the discussions had gone to the point where the state was prepared to prepare an accusation. He was prepared to plead to the accusation and apply to PTI. Is that right? Ms. Dianuntis, I'm still talking to you.
Yes, Your Honor.
Judge, if I could come in, I'm PTI director. He would have to get compelling reasons submitted and okayed by the PTI prosecutor prior to application. Once he's allowed to apply and the report is written, he would have to enter into a plea agreement.
All right, Ms. Linehan, I guess I'm back to you. Go ahead.
Judge, the second degree alleged he was given a summons on it. It involved a marijuana offense where there's an allegation that he had possessed with intent to distribute marijuana, and apparently he had a pocket knife in his possession. So that's the nature of the second degree charge, sir, and he was left on his liberty on that. He did pick up these new charges, a contempt situation with his mother. That's what he was detained on. His mother has dropped the restraining order. I don't know that the second degree charge on the earlier case would even survive presentment to the grand jury. I don't have the discovery on that, but Ms. Dianuntis and I were at the point where I know I would have to plead him on the domestic violence case to get him in, and we would make application. I don't understand why an 18-year-old is required to continue in custody when what we're looking at ultimately is PTI or probation. So given the health situation at this time, he's already been in custody since December, January, February. We're at the end of March. He's got 4 months in. He's got a stable living address. He doesn't have ties to any other jurisdiction. He was in RSP drilling status with the National Guard. He's presently accounted for. He would not, of course, be shipping out to any training, and he's going to have to deal with that situation. So he could be monitored in the community. He has a safe place to live, and conditions can be put on him that would guarantee the safety of the community. His mother was the victim in the case that was brought to the grand jury that quickly. She does not wish to proceed. She has dropped the final restraining order. I know that doesn't control, but it usually has an effect on the outcome of the case. So again, we're looking at a young man who's PTI or probation eligible, and I'm simply asking for his release, considering the fact that the courts are more or less at a standstill.
All right. I mean, I guess I asked the questions about what would we do if this were a normal day and if Mr. Donahue were in front of me, and essentially if we were able to put together the paperwork, it would still require compelling reasons and a decision from the PTI people as to whether Mr. Donahue could even apply, is what I understand. Is a very young, does appear to have family-oriented type issues, where the victim was his mother. At the same time, victims decide not to pursue restraining orders for a number of reasons, and sometimes it doesn't mean that they don't have concerns about the alleged aggressor, and it doesn't necessarily mean that they feel safe. I understand that his living circumstances have resolved, but there's just too many moving parts, and that's no fault of Mr. Donahue and certainly not Ms. Linehan. But I can't make a finding, and I'm not going to make a finding, that the circumstances have sufficiently changed to allow his release. Ms. Linehan, I'm denying your application. Luke, I can go off the record. Thank you.